So I have a question for you, Mr. Ron Coleman. Was the 2020 election stolen?
Sure.
Of course it was.
Of course it was.
All right, ladies and gentlemen, it is my pleasure to introduce today my wartime consigliere. So I couldn't afford his hourly rate, so I invited him to come on to my highly rated show, Friends on X. So, Mr. Ron Coleman, welcome. Welcome
Thank
to
you.
Good.
Thank
Shalom
you. Very
Aleichem.
pleased to be here. Alechem shalom.
All right. So for the benefit of our audience, please, who is Ron Coleman? What is the Ron Coleman origin story, sir?
Well, this guy right here on my screen.
On your screen.
That's Ron Coleman.
Oh, tell me about it, sir.
I'm a lawyer in New Jersey. From time to time, I have acted as a lawyer in many, many other places. There were years when I was a lawyer in New York. I'm originally from New York, but I've lived most of my life in New Jersey. I live in northern New Jersey, in Clifton, New Jersey, not far from where my office is, right here in Newark.
Okay.
I do litigation. I get involved in a lot of stuff that gets attention on the internet and social media, partially because that's where a lot of my friends are, and then people give me the opportunity to help them out of legal problems. And it's also because some of the things I do are worthy of being mentioned in the news. I do a lot of free speech stuff, defamation work. I mean, my background is as a commercial litigator. I spent many years doing intellectual property litigation, especially trademark infringement. I was a very active blogger for about, I guess it was 10 or 15 years. I kind of lost track. 2015, 2005, 2020, I think, actually, that's probably what it was. Yeah. I had a blog called Likelihood of Confusion, which focused on trademark and to some extent copyright law and internet law. And then I gave it up as microblogging kind of overcame blogging. So, and now I'm on Twitter. I have a nice amount of followers for somebody with a real job. And I am, as lawyers go, also as lawyers who have real jobs go, I'm unusually forthcoming on X.com. I say what I think. I pay the price if there is indeed a price. I think it's mostly a notional issue at this point, but and I have a podcast, which is called Culmination.
Good.
And
I'll encourage my my followers to tune into that. Between the
subscribe on YouTube. I love subscribe. I have a YouTube channel. One is called Lawyer Ron Coleman. I had to use the word lawyer because Ron Coleman's a very common name.
Okay.
And
you're not the bench. You're not the weightlifter.
I'm not the weightlifter.
Bodybuilder.
Bodybuilder who built his body by lifting weights. But you're right, he is a bodybuilder.
Yes, sir.
I think 9-time Mr. Olympia or something crazy like that.
Yes.
Great big Ron Coleman. I'm not small, but compared to him, I'm not very big.
Right. So between the two of us, apparently we have one case presented before the Supreme Court. And that why don't you tell us about that?
Between the two of us, there's one?
Yeah. So as far as I know, there's only one between the two of us. So I don't know. You got to start pulling your weight, Ron Coleman. I'm kidding. How is it to argue a case before the Supreme Court?
So my famous Supreme Court case is actually fairly famous. I mean, I do meet people who tell me that they studied my case in law school. It's known as the Slants case. The title of it is Tam versus Mattel versus Tam.
Yes.
Mattel was the name of the commissioner of the United States Patent and Trademark Office at the time. And the reason that his name comes first is because the USPTO appealed from a ruling of the Federal Circuit, the United States Court of Appeals for the Federal Circuit, which we had won. The issue was, can the United States Patent and Trademark Office, or the Commissioner of Trademarks in particular, refused to register a trademark on the ground, which was in fact provided in the statute passed in 1947 governing the registration of trademarks, on the ground that the mark is disparaging.
Okay.
This had come ahistorically to be interpreted as an anti-ethnic slur provision in the law. And I say historically because it was nothing in the history of including legislative history or any other form of history backs up the interpretation that disparaging was meant to prevent the registration of racial or ethnic or lifestyle slurs.
Disparaging to who? According to who? I suppose.
Well, that you see, you're giving away the punchline. But it was passed by a Congress made up of almost entirely white men in the city of Washington, which was a segregated city in 1947. They weren't trying to sneak civil rights provisions into trademark law.
Okay.
It was part of an international treaty. In any event, the Supreme Court ultimately agreed, as you say, it is viewpoint discrimination. The government cannot say, we consider this trademark to be disparaging.
Okay.
We have to, if it's really if it meets all the qualifications for trademark registration, then it's a trademark and we have to register it. No one knows what is disparaging. Part of the context what this arose in fact, was a moment of what was called reappropriation.
Okay.
In which groups that had formerly been known for, not known for, but had previously been afflicted by slurs and insults, were using those slurs and insults as a way, as in an assertive, proud way of saying, you know, that's what you called us? Well, yeah, that's what we are. And you know, we'll shove it down your throats.
Yes.
What I had noticed was that this reappropriation was, you know, the prideful use of words such as queer, dyke, had been approved by the USPTO when it came to sexual conduct, but not when it came to ethnic slurs. And I deduced, and I'll never be able to prove it, but I think it's a really strong inference from the facts, that the people in charge at the USPTO were really just terrified at the idea of a nigger trademark. That was really what it was all about.
Yeah.
Because we know that that's a magic word as it is right now. In fact, I see fires breaking out all around me, looking out the window because I uttered that two-syllable word in Newark of all places. And if the word is uttered or given a trademark registration, then the world will come to an end. But that's just not how law is supposed to work. We didn't make the argument of reappropriation. Well, we kind of made it so that the court, really for context, I would have omitted it entirely from the brief, but reappropriation is an irrelevant consideration because the constitutional issue is the same. The government cannot choose who can say what, and it doesn't matter. In other words, it's not only that it can't discriminate based on point of view, it can't discriminate based on any content. And in particular, in trademark law, it's a silly argument because I could get the registration and then assign it to anyone I want to.
Okay.
So if you have, in fact, at one point I said to my client, Simon Tam, the head of the Slants band, I said, you know, if you really just want to get this and not shake anything up, we can find Thurston Howell III and have him apply for it, and they won't be able to say that it's being used by you in connection with Slants, which is an obscure, probably 100-year-old slur.
Derogatory
Yeah,
slur, yeah.
yeah,
Not
and
really in common parlance.
no, not really. And he said, "Nah, it's not what I'm going for here. I want to really challenge this law on the merits."
Mm.
So that's how it went. And as a result of winning that case in the Supreme Court, the Slants were allowed to get their trademark registration, and the law of free speech in this country was a little bit broadened to include a very clear principle that the government may not apply viewpoint discriminatory filters on the provision of benefits that are otherwise available to parties that are not being discriminated against, unless that discrimination is part of a congressional plan. In other words, if Congress, now this is before the before affirmative action was ruled to be unconstitutional. But in theory, if Congress wants to make a law that says we want to encourage minority sculpture, sculptures by minorities, by minority sculptors, then Congress has made the choice to, to encourage that, and then the discrimination would be legal. But the trademark registration statute was never about that. Now, many people were concerned. Many people have said that, well, Ron, if you win your case, aren't there going to be all these nigger trademarks
immediately the next day,
and kike trademarks and all WAP trademarks? And I said, well, it's possible that there would be. It's literally possible in a way that it wasn't possible before. But as a practical matter, under U.S. trademark law, you don't get to register a trademark unless you use it. And I don't think in the year 2020, well, it was 2017. I don't think in this time in history, people are going to be able to use offensive trademarks in a way that will qualify them for registration. And it turned out that I was right. The world did not come to an end. And in fact, the case that was sort of in a race with us to get to the Supreme Court, which was the Redskins case.
Yes.
So activists were trying to get that trademark canceled, that trademark registration canceled.
As they did with Aunt Jemima, as they did with the Land of Lakes.
But see that those, well, maybe people also tried to get those canceled. I don't know, but they all of those, including Redskins, stopped being used because of the social forces, not because of the law, not because of judges protecting us from ourselves, but because of commercial concerns.
Pressure.
And that's why the law should be neutral, because the market, if indeed these are valid criteria for social opprobrium, then society will act accordingly, and it did.
So the argument that if you self-apply or reclaim a derogatory term, which was historically used against you, that's irrelevant. Whether I'm black or not black, I could still make a trademark or register a trademark with nigger doc, whatever the case may be.
Absolutely, it could not. And in fact, one of the things I really wanted the Supreme Court to take up, and neither they nor any of the courts that preceded them would do so, because it was just too hairy. I said, what business does the U.S. Patent and Trademark Office have determining whether an applicant is Asian? Are they going to employ a Nuremberg test?
It'd be illegal to ask, wouldn't it?
You would think it would be, but actually one of the grounds for refusal of registration at the administrative level was, even though the word slants is an English word, we know, Simon Tam, that you intend to use it in connection with your Asian American band because we know who you are and you're Asian American.
Yes.
Well, what if he was only half Asian? What if he was what if he was a
Yeah.
quadroon? Okay. At what point, why should USPTO examiners be getting into the family trees of applicants? Nobody
Irrelevant.
wanted to touch that, though, and it wasn't really necessary for the
Yeah.
constitutional decision, but I
Mm.
would have really liked that to have been addressed.
Mm.
So,
Just
nonetheless,
have to leave it the way that it is. That's is there anything in particular that helped? Because I feel like the Supreme Court is very selective about the
oh,
cases
great question.
that they want to take, and so many things that we as citizens be like, I would really love for them to take up this case.
Oh,
They
yeah.
won't touch it. And so how do you trick it in a way that they'll actually pick it up?
Fantastic question. So we had a couple of things going for us. One of them was that so when you appeal from the patent office, you can either go to a district court,
Mm.
which is the trial level court, which is what the Redskins did. They went to a court in Virginia, or you can go directly to the United States Circuit Court for the federal circuit.
Okay.
We chose to go to the federal circuit because we didn't want to. So the advantage of going to the district court was that you can add new evidence.
Mm.
Whereas if you go to the circuit court, you've locked
It's locked in.
record down. Right. We
Okay.
liked the record that we had
Okay.
for our case.
And you're licensed to represent in federal court.
Oh yeah. I mean, I'm admitted to every circuit court.
Yes. Okay.
So one of the judges on the federal circuit, as it happens, has had an issue with this provision of the trademark law. Section 2A of the Lanham Act, which prohibited registration of disparaging marks. This has been kind of her bugaboo since she was in law school. So she was waiting for the opportunity to push this issue. Meanwhile, the Redskins were proceeding through the federal court, and they were now through the district court, and they now had a pending appeal in the Fourth Circuit Court of Appeals, which hears appeals from the district court in Virginia. And the I have always believed the Supreme Court knew that eventually they would be faced with this appeal
from one direction or another.
Well, not only that, it was, first of all, it was a very high profile case. Second of all, they knew the Redskins were right. They knew that this was unconstitutional.
Okay.
But it was politically a hot potato.
Yes, which they avoid.
So to rule in favor of the Redskins would have been to say, corporate America can decide what slurs it wants to use, no matter how much the people affected by it are hurt. And on the other hand, our case was actually the party that wanted that was moving the ball was a reappropriation party. So even though his reappropriation argument is constitutionally irrelevant, politically speaking, it was a much more appealing case for the Supreme Court to take up. So they took our case and not the Redskins case, and the Redskins benefited from the outcome, which is part of the reason they helped us, which they did.
So the precedent is set. They can do it on your case. They don't have to touch the Harry case, and then they can accomplish what they want to accomplish with one and get out not having to kind of touch something a little bit more complicated. Yeah, it's like playing chess, I guess. It's
there's a lot of that.
Very tricky.
A lot of strategic stuff goes on that we don't really ever.
Absolutely. That's like inside baseball right there. My next question to you, as I look at your CV, something that stood out to me is this. So I have a question for you, Mr. Ron Coleman. Was the 2020 election stolen?
Sure.
Of course it was.
Of course it was.
Of course it
I
was.
was, I mean, my personal involvement there was I was
Yes,
in Philadelphia at the convention center
correct.
when I was standing there with Pam Bondi,
Okay. Is
when
she
we
the
had
right choice, or would you have preferred Matt Gaetz?
I think she's a better choice than Matt Gaetz. Matt Gaetz he has problems, and I don't really see him. I think Pam's going to be fine. I
Mm,
think she you know she needs to get her sea legs a little bit,
sure. Give her a
but
minute.
I'm not worried about her. Um, but we had an order
Mm,
from the Intermediate Appellate Court in Pennsylvania requiring that they allow observers into the mail-in ballot counting in Philadelphia County. They ignored it. They knew that the Pennsylvania Supreme Court would overturn it. That doesn't
mm,
mean there was no stay in place. They had no right to ignore that order,
mm.
but the sheriff of Philadelphia County would not enforce it. We asked them to. And the real question is, why would you object to somebody watching the counting? Why would
Right,
you object?
right.
Now, that anecdote doesn't, in and of itself, prove, in the sense of direct proof, that the election was stolen, but all the other information, all the 81 million votes, come on. This
Yeah.
guy excited no one, motivated no one. He had no one came to his rallies. It was absolutely cooked. And all he needed to do was do what they did in Philadelphia, in Atlanta. And you look at the extent to which both parties in power in Georgia have
Yes.
gone out of their way to destroy evidence of what happened in the 2020 election, and the extent of cheating in major cities is just, I mean, it's an open secret. It's not really debatable. It the idea that this was in any way litigated is pretty preposterous.
See, that's one of the arguments that people make is like, well, the court overruled that, or the court didn't touch it, or they didn't have jurisdiction, or they feel that that was satisfied in some way and use that as evidence. Like, well, there was nothing, there's no there there.
There's plenty of there. The mail-in voting is inherently, I mean,
Sure.
a bipartisan commission 20 years ago making recommendations on elections said, whatever you do, don't move towards mail-in voting. It is a fraud machine. So of course we moved toward mail-in voting.
Yeah, but now that's one of the other issues too, because it's extremely dangerous. That was a very, very dangerous game to play. I mean, ask Rudy Giuliani, Mark Meadows, John Eastman, Jeffrey Clark, Sidney Powell, Jenna Ellis, et al. In Georgia. Those guys got hammered, and a couple of them have already pled, even though the case itself looks like it may be dismissed. So we have a
Yep.
couple of issues there. It's a kind of a racketeering. Can you shine a little light on what that is? And whether it even has standing in court?
Well, I think it's super troubling. I'm not really qualified. I never really looked very closely.
Mm,
I mean, I think they used racketeering charges that hinged on election interference. Uh, it was really an egregious abuse of prosecutorial power
mm.
and the way they went after Rudy Giuliani. I've always felt badly about that. I was on the phone with him the election night, um, talking about these causes of action and what we could claim and where. And did he and Sidney Powell did they get ahead of themselves? They may have, but the idea that this was criminal conduct that our political um, system can't handle, even if everything they said was wrong, which it wasn't. Although
Mm.
much of what Sydney in particular, I think, ended up repeating might have even been an op to make a fool out of her.
Mm.
I'll never, well, maybe some people will know, I don't know.
Okay.
But the idea that you use prosecutors for this, and that and also the way Giuliani was bankrupted,
He's been
um,
disbarred, has he not?
and just yeah, it's just an absolute travesty of the law, and the use of state attorney general's offices
Mm,
as political hit squads is one of the biggest problems we have to face. If indeed President Trump succeeds, as we certainly hope he will, in cleaning up the federal law enforcement system, the states are still a problem, and federal law enforcement does, as it should, have a role in that cleanup process. But there's a lot of work to be done, and there are definitely hurdles to getting it done, as well as, and many of them are political hurdles, because the politics of a lot of these states work in a way that the people who put these characters into power like the way they're abusing their power.
yes, that's done intentionally.
Right.
It seems a dangerous precedent to me to be able to begin to take action against someone's attorney. Your attorney is representing you, and here's what you believe, and is there to represent you. This obviously has a chilling effect on other people who may be inclined to come to your defense. I believe that is the tactic that they're trying to use.
You're 100% right. And it is also shameful just how poorly the organized bar, all of a sudden, they woke up when there was criticism last week of certain attorneys. The ABA issued a statement, but in the high water point of lawfare, let's say 2 years ago,
Mm.
when, or even before that, when Michael Cohen was allowed and required to testify to all kinds of aspects of the attorney-client privilege.
Yes. Willingly or unwillingly?
Yes,
Exactly.
he was quite willing, because that was part of his deal. Obviously, he wanted to be as cooperative as possible. But the
Sure.
idea that a lawyer could do that, don't give me this crime fraud exception. They were virtually pro pass. It's not a crime to pay
Mm.
hush money to, nor was it proven ever, really proved. Nor it was never proved that Donald Trump ever did it. Well, maybe some
Mm.
people consider it to be proved. I don't.
Okay.
I wouldn't kill me if he did, but you can't just assume that it's not as if it's ever been adjudicated. So
Sure.
all kinds of, no one, silence, the civil rights people, silent, the organized bar, silent, the criminal defense bar, which, is full of activists, silent.
Mm.
So we see it's war.
Yeah, indeed it is. So the U.S. Constitution establishes separation of powers, and the first three articles lay out the branches of our government, I don't have to tell you. So the Article 1, legislative branch, I think it's clear that Congress is utterly fucking useless, let's just say. So this is not just my opinion. A Gallup poll came out February 19th. It found that 29% of U.S. adults approve of the job that Congress is doing. But wait, this is up from the previous month, and that's due to the fact that Trump is in the office, and it was, I don't know, a 12-point increase from the previous month. Basically, everybody believes that Congress is either corrupt, inept, or something else. That leaves us then two branches of government: Article 2, the executive branch, and then Article 3, the judicial branch. It seems to me, what is your opinion of this, sir? It seems to me that our government functions on executive order, and then waiting around for the Supreme Court to, like Caesar at Colosseum, thumbs up or thumbs down.
Well, in a way, that would be a relief if the Supreme Court really would do thumbs up or thumbs down. What we see instead is Supreme Court avoiding
Mm.
a shameful amount of the important constitutional issues that it should be ruling on, and also issues that are not necessarily constitutional in and of themselves, but which are what we call circuit conflicts, where the law is one thing in the Ninth Circuit, and it's in California, Washington, Oregon, Hawaii, but it's in Arizona. It's another thing in the First Circuit or the Second Circuit or the Fifth Circuit. The Supreme Court is lazy. They don't, frankly, they don't work enough. They should be hearing a lot more cases where their jurisdiction is not mandatory, and that's not working. But as you point out, Congress is worthless. Whenever, there are a lot of things, a lot of problems that are coming before the judiciary that should really be handled by the legislature.
Yes.
And Congress has been worthless for coming on 10 years now.
Yes.
It doesn't pass budgets. It doesn't decide or debate policy. It's merely just a wrestling match for partisan voting.
It's optics, it's pork spending, it's
it's an absolute disaster. But the judiciary is terrible. The Supreme Court doesn't rein it in. And the executive, they issue the executive does issue executive orders, but the judiciary routinely second guesses the executive, including
yesterday.
With respect to every minute, no matter when people hear this, it's going to be happening. They simply consider themselves to be in the position of philosopher kings. They assert nationwide jurisdiction regardless of the actual statutory and constitutional limits of their jurisdiction. And they say, I don't think that was a good decision by the executive. I think it should be done differently. And it's a disaster. It's a disaster. And I do think under the configuration of political and institutional configuration that we have now, that there will be positive change, that there eventually the Supreme Court is going to make substantive rulings on constitutional issues, but it's painful getting there and unnecessarily painful. I mean, we're living today in a world where Justice Alito wrote in a dissent in which he was joined by 3 other justices, "I'm stunned. I'm stunned." And this is someone who's been on the Supreme Court for decades.
Who doesn't get stunned?
He doesn't get. In fact, I never even knew that he had feelings, or that he would acknowledge. Being stunned means that you lack foresight with respect to an occurrence.
Yes.
And he is a brilliant man, Justice Alito, but here we know what happened today was really a punt. Supreme Court wants the district court to elucidate its unconstitutional order more clearly, but in the process, it seems to be ordering the Trump administration to pay $2 billion that it will never get back.
Correct.
Pursuant to this patently unconstitutional order, and very, very disappointing.
Yeah, it's unbelievable that it undermines the executive branch, and it goes back to, in my opinion, you'll have Trump will issue in his the 45 issued a travel ban for certain countries, and the Supreme Court weighed in that that's okay, you can do that. Biden, I believe, attempted to waive everyone's student loan, and I believe that the Supreme Court may have said, well, you can't do that, or that's not a thing. Sorry about that. So it just kind of executive order. And it seems to me that when the founders intended to create stability over the long term, so that you don't get one guy in power running right too far and you want to pull him back to the center. But instead, it seems to me that US policy is schizophrenic. For 4 years, we're doing this, making agreements, Paris Accord, la, la, la. And then 4 years, we go the opposite direction. We're cutting all of our agreements and everything else. To me, and other, for example, China has 100-year plan, 1,000-year plan. The United States has barely a 2.5-year plan till the midterms, and then it's schizophrenia. What do you feel about that? What did the founders get wrong? What did they not foresee about our current era?
That is a great question.
Thank you, Ron Coleman.
You're welcome. I don't think they ever imagined that statesmen, and it's it's neuter.
Statesman,
It's neuter.
statesman.
I don't mean men and women yet.
Sure, of course.
But in their world, people who would be members of the Senate and members of Congress would feel some level of moral obligation
Mm,
to be conscientious. They weren't naive about why people seek to why people seek power. They weren't
yeah.
naive, but they put checks and balances so that overall those inclinations would be smoothed out. They'd be
Yes.
canceled out. They didn't understand that we would ever move into a world where so many interests were dependent on the maintenance of what they would regard as an impossibly intrusive and expensive state,
Mm,
which has interfered, first of all, with the incentive system. They didn't count, and I'm this is all from the shooting from the hip, but I think it's not a bad answer. They didn't count on the distortion of incentives that would result from involvement in a permanent state. And I
mm.
don't mean the deep state, although that is part of it, but the idea that people would be in Congress and in the Senate for their entire adult lives
40, 50
would
years.
never have occurred to them, and that they would accrete so much power. So there's also, I think, a serious question. I mean, I believe that judicial review is a real thing. Marbury versus Madison was decided right, because otherwise, what power does the judiciary had? It has none.
Mm,
But the founders would not have dreamt that when the judiciary frustrates the will of the people as reflected in the most democratic of the three branches, which is the legislature,
yes.
that the legislature would sit there and take it.
Mm,
And this has happened since the 1960s, when the Civil Rights Act passed. And yet the Supreme Court said, well, affirmative action, discrimination is okay if it's reverse discrimination.
yes. Yes.
Congress at that moment should have stood up and said, no, 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 no. We definitely didn't write that. But
Yes.
hey, Supreme Court, that's how you read it? We'll fix that.
Mm,
They didn't have the moral courage to do that, or the political courage. And that's one of a million examples of where the judiciary has been allowed to sculpt the legislative process in a way that the founders would just have been dumbfounded by. How is it that? So, I mean, I think at the end of the day, the simple answer to your question is the founders, I believe, would have thought the legislature would be a lot better
yes.
than it is.
Yes. Yes. Do you see any sort of remedy? Because it occurs to me, okay, at least one of the three branches of our government is completely paralyzed. We're down, in my opinion, to two effectively, and executive order and being overruled. There's a growing sense, firstly, from the Democrat side of wanting to, as they say, just stuff the court. Let's get 12 people, let's get 20 people, let's get 50 people on the Supreme Court. And then on the other hand, I'm seeing more and more of these memes like the Andrew Jackson quote where he says the court has made their decision, now let them enforce it. So this is very problematic because if the the Supreme Court of the Judiciary is utterly undermined, and I think it's currently beclowning itself, then we've got a big problem.
So I like that Andrew Jackson quote. It's cute. Andrew Jackson, however, was no scholar.
Mm,
In fact, he was something of a bully.
okay.
Not really. I mean, he's an important president. He does great things, but he's not necessarily the best model. And I don't know that he's a source of constitutional wisdom.
Sure.
I I don't have any problem with conservatives, Republicans declining to remove the disobedience of an unconstitutional order from the negotiating table.
Okay.
I think so in other words, I was watching the Senate hearings involving my former partner, Harmeet Dillon and others,
Mm,
and they all avoided answering that question.
okay.
I think that's okay because if you can keep a card on the table, unplayed, then keep it unplayed.
Mm,
At the end of the day, though, I think I'm sensing from your question that you'd agree with me. If you don't listen to the court, there's no end to it.
what's left?
And the fact that Biden basically ignored certain Supreme Court rulings, it's a little bit of a vague assertion. What would happen is there would be a ruling about this program or this order or this administrative action. They were all attempts to do the same thing, which any fair reading of the Supreme Court opinion with respect to the first one, well, first of all, there's no fair reading at all that would have legalized what Biden was doing. It was
Sure.
always political BS. In any event, the fact that Biden did it doesn't, even if you want to say he did it, doesn't mean that it's the right thing to do.
Yeah.
It would cause a greater constitutional crisis than the one we're experiencing. And as we've both said, what's left of the judiciary if we're not going to respect its rulings?
Sure.
Fair. I think the 17th Amendment ideally should be repealed. It's not a cure-all. Many of the state houses are every bit as corrupt and awful as the present representatives, the popularly elected senators themselves. But one thing it does do, you would hope, well, actually, one of my problems with the Senate is carpetbagging. The
Okay.
idea that Hillary Clinton, who has in her entire life has nothing to do with New York, moves to New York and becomes United States Senator for the state of New York is offensive.
Sure.
You might say, well, so there's a response to that, which is, well, obviously the people in the state of New York were not offended. Okay, well, that's a democratic, small d, response. And I'm rewriting the Constitution in response to your question. So
Okay.
that's an area in which I'm going to trend more toward a non-democratic response, especially because sending it back to the state house doesn't really make it less democratic. In fact, it is a great federalism remedy.
Yeah.
And still the people in the state house are, in the state legislatures are elected by the people of that state. So if those politicians, I mean, it's kind of funny because New York's present Senate representatives, utterly garbage people.
Yes.
They actually typify exactly what you would get in a Senate full pre 17th Amendment.
Okay.
but you at least you wouldn't get these clowns who are just famous for being famous
Yes.
and are not respected locally and have not paid their, the Senate should, I mean, the Senate should not be so I would fix the Senate. I think that would fix the Senate.
Okay.
And it
17th
would
Amendment, repeal it.
repeal the 17th and also get it's an amazing thing to think. If Congress today were to pass an amendment, which would be difficult because the Senate wouldn't want to do this,
Sure.
but if the Congress were to say we're going to send this amendment to the states for ratification, which would then be subject to ratification by the several state legislatures,
Okay.
it would probably lose. That's how mindless and politically oriented the today's politicians are. They instead of having the opportunity to take back power, they would decline because the donors and the central party committees would tell them, especially on the Democrat side, not to do it. That's a change I would make nonetheless. I do think that there are a number of changes. I think election reform has to take place.
Yes, indeed.
And the Constitution provides for it to be done at the congressional level, and it ought to be done. Not because, at the federal level, not because the feds are, we've seen, can be incredibly corrupt, but there is a level of accountability at the national level that, at least theoretically, we should have a national election day. The Constitution provides for an election day. The idea that there's an election month as we have now, is just preposterous.
Yes.
Too many political judges making too many political decisions at the state level. Look, if people are not going to behave honorably in public office, there's only so much reform you can do because the system is always going to depend on trust. You can't fix that. But maximizing transparency and maximizing accountability, anything that trends in those directions, I'm probably going to be in favor of.
So when I type the word lawfare into a Word doc, it's underlined in red. So apparently Bill Gates does not believe in lawfare. So what is your view on this? The saying that the punishment is the crime. Putting, the things that are happening in New York, for example, with Trump, or the notion of having a jury of your peers in a place like New York or one of these other districts. Is it even a thing to have a jury of your peers anymore? Is that possible?
Well, I think it's been rendered meaningless.
Why?
Were people on the Trump jury peers with Donald Trump in any meaningful sense?
Good point. Well, they were residents, let's say, of New York or whatever the place. But what does it mean you're
the jury system is a funny thing. I had been really down on it until I won a verdict a couple of weeks ago. I said, the juries are okay after all.
I kind of like you jerks.
They were, and I spoke to the jury afterward and was really I was impressed with and included, it was in Washington, D.C.
Okay. That's another place, though. Good luck.
All right, so you've seen my tweet, certainly.
Sure.
My pinned tweet. We've got to get rid of the D.C. Circuit and the D.C. District. It doesn't work. It's over politicized. Nonetheless, I was in that court. This was a jury made up of men, women, white, black. They were all on the ball. They all got it. They weren't fooled. It was a real pleasure. It really was. But it was a relatively unpolitical case.
Sure.
And it worked out. Yes, juries are a problem. Lawfare is a real thing. The way the assignment of look, the biggest scandal that nobody knows about, except people who actually practice litigation as I do, is judge shopping is wildly out of hand, and it is assisted by the judicial system which does not, despite its promises, it does not assign judges randomly.
Yes. So Steve Bannon apparently got the same judge as Juan Merchan, I guess, got the same judge as Trump. It's like just randomly, right?
Yeah, no, it's ridiculous. I've seen it in action myself. Certain judges get every kind of case involving certain things.
Mm.
It's a travesty, and this is something that should be investigated. I don't really know exactly what the right office for it would be. The Supreme Court ultimately has responsibility for this.
Good luck.
I mean, that's in the that's in the federal courts.
Mm.
I mean, the states can run their courts however they want to, but they all claim to be random assignment, I believe, and it's a lie. So if there would be some attention paid to this issue, I think that would improve things a great deal.
Interesting, interesting. Who would win in an arm wrestling match between you and Ben Shapiro?
I think that as a physical specimen of robustness, Ben is one of the few people I can say is smarter than me.
Seriously, you're actually admitting that.
I think Ben's brilliant. Ben is brilliant, and I envy his success. But I don't think he would last very long in arm wrestling with me. And I'm an old man, but I am robust.
Hey, at the end of the day, what else do we have? Let me ask you.
Well, at the end of the day, that's the last thing we have. I mean, I'm in better shape now than I was 3 or 4 years ago because I've been working out, but the long-term prospects for my strength are not really that good.
So
I'm going to turn 62 next week.
Hey, good. Happy birthday to you.
Thank you.
So you're not calling out Ben Shapiro for a duel or anything. No,
nothing like that.
Ring.
You know, it's so for years I've been trying to figure out why Ben so assiduously ignores me on Twitter. And I don't chase after him on it.
Okay.
But it would seem like, and in fact, we used to be on a blog together. It's a blog that you can't even find anymore. So we had some communications. And then I was looking at some old screenshots that are in my Google Photos. And I found one where I said, I've just had it with Ben. And I think just since then, he said, okay, I'm on the list of people he's not going to interact with anymore.
We just muted you.
But the fact is, I had a tweet 2 weeks ago that was so damn good, he had to retweet it.
Okay. All right. A little bit of love happening there. So a couple of more questions, and I appreciate the time that you've allowed. Copyright, that's one of your specialties. So AI, this is creating an issue, I would say. So, for example, you're able to take Taylor Swift's face and make porn with it, with AI and all the things like that. An image that you believe to be yours could be manipulated or used for something else. You don't know if it's real, if it's a deep fake. What do you predict some of the issues going forward may be related to your image, being able to preserve the integrity of your image in the era of AI?
The rights in your own image are not really copyright issues.
Okay.
A particular picture of you is a copyright issue.
Okay.
But your actual face is just your face, and it is protected by most states.
Okay.
It's really a marginal issue, but for people like Taylor Swift who are famous, it's going to be, I think, an ongoing annoyance, and there's nothing legally that we're really going to be able to do. It's a little bit like the pornography issue. I think the Supreme Court did a terrible job with defining the outlines of obscenity, which is not protected speech. They have really made it almost nothing. But even if they had done otherwise, I don't think you could do anything about it.
Okay.
In an age of universal connectivity in the dark web, it is a force of pornography is pretty much a force of nature. I'm not saying that therefore give up on regulating it and or giving up on regulating the misuse of people, again, the deep fakes. But it's part of the world we live in that people, if you're going to choose to be a public person, you're going to have to tolerate a certain degree of abuse from the world, especially because anonymity is so prevalent.
Okay.
People can get away with things that they would never have dreamt of doing when you and I were growing up. You're not my age, but even when you were growing up, much
Mm,
less when I was growing up, if you wanted to distribute something, you had to get someone to publish it, or
sure.
you mimeographed things and pinned them up at the shopping mall, okay, and it would basically become irrelevant, blown away by the wind pretty fast.
Yes.
Now everyone can say, can and does say everything, and there are many, many fine things about that, and especially, I mean, I'm not a fan of gatekeeping. I would never have been able to make a living. I think well, God knows how we would have provided for me, but
Mm,
the internet has been a great boon for me. It's enabled me to say what I need to, and for people to find out who I am and what a great lawyer I am, and
yes.
to give me money to help them. And I need that. But things change, so we can't necessarily fix it by clucking our tongues or by making laws.
Mm. Last question, defamation. Defamation. This is a very serious, like the largest settlement in the history of human race. Alex Jones, $965 million verdict. You've got the Fox Dominion defamation case, $787.5 million settlement there. Defamation is one of the largest, I suppose,
It's just a form of lawfare, what you're describing.
instrument of lawfare. What do
Yeah,
you?
but that's what it is. I mean, this is a crisis, another legal crisis created by the judiciary, which has enabled defamation law to become a free-floating per se tort.
Hmm,
Alex Jones stupidly and callously allowed himself to, not allowed himself, stupidly and callously tortured parents whose children had been murdered
hmm,
in a terrible tragedy for his own reasons.
okay.
And there's no really good legal way to capture that, to penalize someone for doing that.
Yeah.
So we
You.
said, well, how about defamation?
Hmm,
That's not that's not how to make law. Same thing with Giuliani and the Fox case and
hmm.
Trump, and defamation and the problem is that these are the state courts are just so corrupt and so politicized that in that state level it's going to be hard to undo this, and at the same time at the federal level this is an issue that the Supreme Court should be looking at, and I don't know if I'm going to live long enough for them to do their job and get to it.
Limiting defamation settlements then.
Well, settlements, judgments, you can't limit a settlement,
Okay.
but the Fox case, that had more to do with Fox. There was a lot going on there. I wasn't privy to it, but
Well, presumably Tucker Carlson lost his job over it. Dan
yeah,
Bongino, it seems, may have lost his job over the entire thing.
yeah. I
So,
mean, who right? And I think that has a lot to do with the internal and corporate politics,
hmm,
and I don't think you can deduce much from that except that yeah, these are gigantic systemic problems. They are, and if I were in charge, I probably could come up with ways to fix them. But all I am in charge of right now is the words that come out of my mouth.
hmm. Last question. What is the biggest threat to America and why is it Norm Eisen?
Checks out.
Hmm. Have you ever seen him on the other side of the table? Have you ever?
No, no, no. I've never have. He's a truly terrible person, but he's a representative of a very, unfortunately, large um, cadre of really bad actors who have been able to get their hands on a lot of money to do a lot of harm to the American system. And I hope that change is going to come in that category.
Interesting. Interesting. What do you see for the future? What is
This is the third last question.
the third last question is the following. What do you see over the course of Trump? What do you predict? Trump 47. Any big predictions?
He will be remembered as the most consequential president of our lifetimes. And believe me, I didn't expect I'd ever say that,
Hmm.
but I see it happening. I don't know that
Interesting.
he's going to win every battle he's involved in, but he is moving the framing of all, he is reframing all these issues the way we discuss them, the way we approach them. And he gave a speech last night that got approval ratings in the 70 to 75% range among all who listened to his speech. That's mind-boggling.
Yes. Yes. It's unbelievable. Even if he doesn't get done half the things that he wants to get done, he still ranks amongst the most
A little bit
consequential.
of light dispels a great deal of darkness.
Interesting. Very good. And with that, I will take no more of your time. Sir, thank you very much for your time, Ron Coleman. I appreciate
You're
you coming
welcome.
on and shedding a
My
little bit of
pleasure.
light in these troubled times.
Thank you. Thanks for having me on. Great talking to you.
All right, sir. Thank you so much. Appreciate you.
So,